Welcome to episode 2 of the Succession podcast. An audio-video reviewer on the law on succession based on the book by Paris. In this episode, we will delve into Chapter 2. Chapter 2 is divided into several sections and subsections. In this episode in particular, we will be going into detail on Section 1, Subsection 1. Section 1 is entitled Wills and Subsection 1 is entitled Wills in General. Let's begin. Article 783. A will is an act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of his estate, to take effect after his death. This article provides for the definition of a will. Also in this article, we discuss the essential elements and characteristics of a will. It is important to remember that the making of a will is a statutory right. It is a natural right. This means that the source of the right is the statute itself. In this case, it is the Civil Code. Why is this important? Being a statutory right, the making of a will should be considered subordinated to both the law and public policy. The making of a will is a unilateral act. As such, no acceptance by the transferees is needed while the testator is still alive. It is also a solemn or formal act. It is considered so because it is executed in accordance with the formalities prescribed by law. In order to make it effective, the will must have been done with the intent to make a will and the testator must be capacitated to make a will. The will is also strictly a personal act in all matters that are essential. The will is effective mortis causa. It produces effects only after the death of the testator. It is also essentially revocable or ambulatory. If the testator can bequeath his property in the will, then he shall also have the right to revoke the same, subject to the provisions of law. The will must be free from vitiated consent. It must have been executed freely, knowingly, and voluntarily. Otherwise, it will be disallowed. It is an individual act, if executed by a Filipino living in the Philippines or abroad. It must be noted that Philippine law does not allow a joint will. A will disposes of the testator's estate in accordance with his wishes. However, it is done only to a certain degree because legitimes are reserved for compulsory heirs. Article 784. The making of a will is a strictly personal act. It cannot be left in whole or in part to the discretion of a third person, or accomplished through the instrumentality of an agent or attorney. Note that the mechanical act of drafting may be entrusted to another, as long as the disposition itself expresses the testator's desires, and all the formalities of law are complied with. The will must still be signed by the testator and the witnesses in the case of a notarial will. Meanwhile, for holographic wills, the same must be copied by the testator in his own handwriting. In making a will, it is strongly advised that one employ an attorney. This is because there is a strong presumption that the will was regularly made. Article 785. The duration or efficacy of the designation of heirs, devisees, or legatees, or the determination of the portions which they are to take, when referred to by name, cannot be left to the discretion of a third person. This provision reinforces the rule that the making of a will is strictly a personal act. As such, testamentary power cannot be delegated to another. Article 786. The testator may entrust to a third person the distribution of specific property or sums of money that he may leave in general to specified classes or causes, and also the designation of the persons, institutions, or establishments to which such property or sums of money are to be given or applied. The previous article, Article 785, speaks of the non-delegability of the testamentary power. This article, however, provides for instances when a third person may be entrusted. The two articles do not contradict each other. In the present article, the particular names are not designated. In this article, a class or a cause is what is specified. Article 787. The testator may not make a testamentary disposition in such manner that another person has to determine whether or not it is to be operative. Again, this article speaks of the personal nature of the testamentary act. Article 788. If a testamentary disposition admits of different interpretations, in case of doubt, that interpretation by which the disposition is to be operative shall be preferred. It must be emphasized that this article only applies if there is doubt. Article 789. When there is an imperfect description, or when no person or property exactly answers the description, mistakes and omissions must be corrected. If the error appears from the context of the will or from extrinsic evidence, excluding the oral declarations of the testator as to his intention. And when an uncertainty arises upon the face of the will as to the application of any of its provisions, the testator's intention is to be ascertained from the words of the will, taking into consideration the circumstances under which it was made, excluding such oral declarations. There are different kinds of ambiguity in a will. There is the latent or intrinsic ambiguity. This does not appear on the face of the will, and it is only discovered by extrinsic evidence. In a will, this kind of ambiguity arises when there is an imperfect description of the heir, legatee, or devisee. It also arises when there is an imperfect description of the gift being given. Also, it happens when only one recipient is designated, but it turns out that there are two or more who fit the description. The other kind of ambiguity in a will is the patent or extrinsic ambiguity. This kind appears on the face of the will itself. If the reader examines the provision itself, it is evident that it is not clear. How may an ambiguity be cured? First, by examining the will itself. Second, we can rely on extrinsic evidence such as written declarations of the testator. This is possible because the law allows us to get the testator's intention from the words of the will and the circumstances under which the will was made. Article 790. The words of a will are to be taken in their ordinary and grammatical sense, unless a clear intention to use them in another sense can be gathered, and that other can be ascertained. Technical words in a will are to be taken in their technical sense, unless the context clearly indicates a contrary intention, or unless it satisfactorily appears that the will was drawn solely by the testator, and that he was unacquainted with such technical sense. This article provides the rules for the interpretation of words in will. Ordinary words have their ordinary meanings, except when there is a clear intention that another meaning was used, provided that the other meaning can be determined. The same goes for technical words, unless there is a contrary intention, or if it appears that the will drafted by the testator did not know the technical meaning. Article 791. The words of a will are to receive an interpretation which will give to every expression some effect, rather than one which will render any of the expressions inoperative. And of two modes of interpreting a will, that is to be preferred which will prevent intestacy. More rules on the interpretation of wills. The previous articles provided for rules on interpretation of words. The present article discusses the interpretation of the will as a whole. It must be remembered, however, that while testacy is preferred over intestacy, this is true only if the will has been validly made. Article 792. The invalidity of one of several dispositions contained in a will does not result in the invalidity of the other dispositions, unless it is to be presumed that the testator would not have made such dispositions if the first invalid disposition had not been made. This article discusses the effect of invalid dispositions. Here, it is provided that even if one disposition or provision is invalid, it does not necessarily follow that all the others are also invalid. The exception occurs when the various dispositions are indivisible by intent or nature. Article 793. Property acquired after the making of a will shall only pass thereby, as if the testator had possessed it at the time of making the will, should it expressly appear by the will that such was his intention. This article discusses after acquired properties. The general rule is that what are given by the will are only those properties already possessed and owned by the testator at the time of the making of the will, not those acquired after. However, exceptions exist, in that if it expressly appears in the will that it was the intention to give such after acquired properties. After acquired properties may also be disposed of through a republishing or modification by a subsequent will or a codicil. Article 794. Every devise or legacy shall convey all the interest which the testator could devise or bequeath in the property disposed of, unless it clearly appears from the will that he intended to convey a less interest. The general rule here is that the entire interest of the testator in the property is given, not more and not less. There are several exceptions, however. The testator may convey a lesser interest if such intent clearly appears in the will. He can also convey a greater interest. This can be done through the purchase by the testator or his executor or administrator of the extra interest or by giving its equivalent value to the legatee or devisee. Article 795. The validity of a will as to its form depends upon the observance of the law in force at the time it is made. There are two kinds of validity with respect to wills: extrinsic and intrinsic validity. Extrinsic validity refers to the forms and solemnities needed. It may also be seen from two viewpoints: the viewpoint of time and the viewpoint of place. From the viewpoint of time, what must be observed is the law in force at the time the will is made. Meanwhile, from the viewpoint of place or country, the law observed depends. If the testator is a Filipino, he can observe Philippine laws, or those in the country where he may be, or those in the country where he executes the will. If the testator is an alien who is abroad, he can follow the law of his domicile, or his nationality, or Philippine laws, or where he executes the will. If the testator is an alien in the Philippines, he can follow the law of his nationality or the laws of the Philippines, since he executes the will here. On the other hand, intrinsic validity refers to the legality of the provisions in an instrument, contract, or will. From the viewpoint of time, successional rights are governed by the law in force at the time of the decedent's death. From the viewpoint of place or country, the national law of the decedent should be followed. That is, the law of the decedent's country or nationality, regardless of the place of execution or the place of death. We have reached the end of this episode. See you all on the next episode where we continue with the discussion. Please like, comment, and subscribe for more.